So good afternoon, everyone. Welcome to today's CIPO WIPO webinar on standard essential patents and alternative dispute resolution. My name is Craig McMillan, and I'm a program manager in the Patent Policy and International Affairs Division at the Canadian Intellectual Property Office. We're very pleased to have participants joining us from Canada and abroad for this important discussion, and we thank you for joining us today. Before we begin, just a few housekeeping notes. Microphones for participants are disabled, so there's no need to adjust your audio settings if you're trying to get that microphone to work. We will have time at the end of the session for a question and answer period. So please type your questions into the chat during the presentations, and they'll be saved and addressed during that period. Finally, we have a French presentation that's going to be available shortly, and you'll be able to access that through CIPO's website. To officially open our session, we're pleased to share remarks from the Chief Executive Officer of the Canadian Intellectual Property Office, Mr. Konstantinos Georgiaras. Mr. Georgiaras could not be with us today live, but he has prepared pre-recorded remarks, and we'd like to set the stage for our discussion today, so let's hear from him now.
Good morning, good afternoon to everyone. I'm Konstantinos Georgiaras, the Chief Executive Officer of the Canadian Intellectual Property Office, and it's my pleasure to welcome you to today's seminar. We are here to delve into the important topics of standard essential patents, or SEPs, and alternative dispute resolution, or ADR, organized in partnership with the World Intellectual Property Organization. Our office values its long-standing partnership with WIPO, and I'm immensely proud of our many years of collaboration. In July 2024, this collaboration reached a new milestone as we signed a Memorandum of Understanding with the WIPO Arbitration and Mediation Center to promote alternative dispute resolution services for standard essential patents. We are proud to be organizing this webinar as part of this MOU and are excited about the future possibilities it creates. Today, we will hear from CIPO's patent branch and the Strategic Policy Sector of Innovation, Science and Economic Development Canada on standard essential patents and recent developments in the field. We're also delighted to have with us the Standards Council of Canada and, of course, colleagues from WIPO to address the value of alternative dispute resolution. Today, we will explore not only advancements in standard essential patents and alternative dispute resolution, but also a wide range of other areas that will drive innovation and strengthen the intellectual property ecosystem. I wish you all an engaging and informative session today. Thank you for joining us.
Thank you, Mr. Georgiaras, for those opening remarks and for highlighting the importance of today's discussion. To begin, I'll start by covering some of the basics of standard essential patents to help set the foundation for the rest of the session. So I'll just share my my presentation. Okay, so in this presentation, I'll explain what is a standard, what is a standard essential patent, what is the meaning of the term FRAND, and then we'll look at some of the common issues that arise with standard essential patents and some of the data that shows the rise in these patents that are being declared as standard essential. Let's start with the basics and talk about standards. Everyone probably has a cell phone in their hand or pocket right now, and we all likely have a different brand of phone. Some of us have an Apple phone, some have Samsung or Google phones. But no matter what phone you have, everywhere in the world that you travel to and you try to use your phone to connect to the Wi-Fi, it just works. We don't have Apple Wi-Fi zones. We don't have Samsung Wi-Fi zones. There's just Wi-Fi, and your phone's actually developed to access it. This is possible because our phones are designed to operate by the same set of technical rules known as standards. Standards are simply agreed upon rules and guidelines that establish accepted practices, technical requirements, and characteristics. Industry participants come together to define a standard through a formal standard setting organization, or SSO. You may have seen the letters IEEE or ETSI stamped onto consumer electronics. These are acronyms for some of the better known SSOs in the telecommunications space. Now, a standard essential patent is, as the name suggests, a patent that defines an invention that is necessary to practice a standard. This means that those who implement the standard, for example, by offering products or services to the marketplace, require a license to the patent in order to not infringe it. In most jurisdictions, patents have a term of 20 years from the filing date of the patent application, and that could be quite a long time depending on the technology sector. It's not really in the public interest to have patent owners unwilling to provide required licenses because they would be able to block the use of important technology. Standard setting organizations aren't just technical committees. They also play a strategic role in shaping markets. Once a technology is embedded into a standard, such as a 5G protocol, any patent covering that technology can become essential. But, and this is critical, there is no global certification process. Patent owners can self-declare their patents as essential, which raises questions about over-declaration and transparency. So for example, at Etsy, tens of thousands of patents have been declared essential to the 5G standard, but how many are truly necessary to implement that standard? That's still a subject of debate and litigation. Something I won't really cover in this presentation is the prevalence of patent pools, which provides implementers with a single license to access many patents that are pooled together. The companies that specialize in putting together patent pools will generally assess the essentiality of a patent that is proposed for inclusion in the pool. And this is one measure to combat over-declaration. One of the important safeguards in the standardization process is the FRAND commitment. When a patent becomes essential to a standard, the owner typically agrees to license it on fair, reasonable, and non-discriminatory terms. This isn't a casual promise, it's a formal commitment made between the patent holder and the standard setting organization. The goal here is balance. Patent owners should be fairly compensated for their innovation, but implementers also need reliable, affordable access to the technology to bring interoperable products to market. Without FRAND, standard essential patent owners could potentially hold up entire industries or extract excessive royalties, what's sometimes called patent holdup. FRAND aims to prevent that by ensuring a level playing field for everyone in the ecosystem. Of course, saying FRAND is one thing, determining what counts as fair, reasonable, or non-discriminatory is another matter altogether. There's no global formula for calculating a FRAND rate. Different jurisdictions approach it in different ways, and courts often disagree. At a very high level, fair means that the terms should not be anti-competitive. Reasonable refers to royalty rates that reflect the actual value of the patented technology, not inflated by the fact that it's locked into a standard. And non-discriminatory means all licensees should get broadly similar terms. And I should note that the meaning of these terms themselves is the subject of debate, and what you see here is not a Canadian position. In practice, FRAND determinations draw on a mix of SSO policies, licensing precedents, and court decisions. It's a very dynamic space, and we're seeing more legal disputes as companies challenge each other's interpretation of FRAND, especially in sectors like mobile, automotive, and the Internet of Things. One major issue related to standard essential patents is that disputes related to licensing terms can be complex and can often span multiple jurisdictions. That's where we see the rise of anti-suit injunctions, courts in one country blocking parties from pursuing litigation in another. It reflects a growing tension between the global nature of standards and the national limits of patent enforcement. Another issue is over-declaration, where patent holders claim their patents are essential to a standard, even though they're not truly required to implement it. This muddies the water and can inflate licensing demands. Then there's the problem of patent holdup, where SCP owners demand inflated royalties, and the problem of holdout, where implementers delay or avoid licensing altogether. Both of these slow innovation and raise costs for consumers. Increasingly, stakeholders are turning to mediation and arbitration to avoid lengthy litigation. These alternative methods can be quicker, more confidential, and less expensive to resolve the dispute. Just as a last point before we look at some data, One of the key tools for navigating the standard essential patent landscape is the ability to find them. SCP indicators are now searchable in WIPO's patent scope database for some technical standards. This allows researchers, implementers, and policymakers to identify patents that have been declared essential to a particular standard. While not all declarations guarantee technical essentiality, this increased transparency supports better licensing decisions and market oversight. In 2022, the Canadian Intellectual Property Office directed its economic research team to examine SEP trends. In particular, we set out to explore patent activities across all technology areas with a focus on those that are linked to standards. This work was updated in 2025, and the next few slides present some of our findings. This research drew insights from an international patent database called Patent Vector, and Patent Vector identified nearly 120,000 SCP inventions between application years 2003 and 2022. Of these inventions, the vast majority were filed by large players in the ICT sector, and more specifically in the telecommunications space. Approximately 809 of these inventions were attributed to Canadian innovators. Notably, the data observes that the amount of SCP innovations worldwide grew substantially in these years. In 2020, it was more than 6 times higher than it was in 2003, with a steady increase in the annual growth rate. Because the data presented here is the filing date of patent applications that become standard essential patents, the plateau that you see from 2017 to 2020 and the drop in 2021 and 2022 are attributed to the fact that many of the applications filed in those years have either not yet matured into a patent or have not yet been declared standard essential. The next graph here shows SCP activity in Canada and a few other countries with comparable market size. In Canada, the number of SCPs has been trending downwards over the years. The spike seen on this graph for Canada between 2009 and 2012 was largely attributed to patents by the company BlackBerry, who operated in the telecom space. While Canadian institutions own relatively fewer SCP inventions than leading countries, it can be observed that Canada is relatively on par with France, Germany, and the UK. Of course, the biggest growth in this space is attributed to countries like China and the US. What we see in the data is a high concentration of standard essential patents in certain key technology fields. This patent landscape map provides a visual representation of global patenting activity in the data set that we worked with. This landscape map very much resembles a topographical map with patents clustered and organized around common themes. For instance, the white peaks that you see on the screen, such as wireless access communication systems and mobile station apparatus, which are both tied to the information and communication technology sector, represent the highest concentration of standard essential patents. By way of further explanation, shorter distances on the landscape indicate that patents share more commonalities relative to those that are further apart. That concludes the Intro 101 presentation, and I've included on this slide the contact information for myself and a colleague from the Department of Innovation, Science, and Economic Development. If you have any questions or would like to discuss any of these matters further, please don't hesitate to contact us. You'll have to bear with me. I'm not sure how to stop presenting on WebEx. There we go. Okay. Okay, up next, we're joined by Annika Auer-Olvera, Director of Programs at the Standards Council of Canada. Annika takes us into the fascinating space where intellectual property meets standardization, combination that can shape markets and accelerate innovation. So I'll pass it over to Annika.
Thanks, Craig, and hopefully, can folks see my screen? I can't see it, but hopefully you guys can see it. Yes? Okay, perfect.
Yes.
Good afternoon, everyone. As Craig said, my name is Annika Auer-Olvera. I'm the Director of Programs at the Standards Council of Canada, and I'm thrilled to be here today to talk about a topic that is gaining momentum, but is still often underappreciated, which is the powerful intersection between intellectual property and standardization. Standards and IP are traditionally seen as opposites, and standards are for collective use, but IP is is about exclusivity. But the reality is, used together, these two tools can significantly accelerate innovation, expand global market access, and increase your influence in how industries evolve. So today we're going to look at how Canadian innovators can combine IP and standardization to not only protect their ideas, but lead their sectors. So before we dive into the heart of this topic, I first want to give you a quick overview of who we are at the Standards Council of Canada, because many of you may not actually know that we exist. So the Standards Council of Canada is Canada's national standards body and the country's leading accreditation organization. So we report to Parliament through the Minister of Innovation, Science and Industry, and we operate as a Crown corporation within the federal government. So we don't write standards ourselves, which some people sometimes get us confused with CSA. We accredit and oversee the organizations do, like CSA, UL, BNQ, and so on. Our mission is to ensure that Canada's standardization system reflects our values, drives innovation, supports public trust, and very importantly, facilitates international trade. So now that you know a little bit about who SCC is and what we do, I want to look at how we support Canada's innovation ecosystem through the standardization value chain. So we play a role in three major components of the standardization value chain. So the first is standards. We don't develop them, we accredit the bodies that do. So standards define agreed upon criteria for safety, performance, and interoperability for a service or a product. And more recently, standards are becoming much more socio-technical in nature than purely technical. Accreditation we are also the accreditation body. Accreditation is what validates that an organization has the competence to carry out evaluations. So they're checking the checkers. Conformity assessment, it checks if a product or service meets a standard. So for example, in the aerospace industry, standards define material tolerances. And accreditation confirms the lab can test to that specification, but conformity assessment ensures that parts meet the criteria before flight. So it's a layered system. Of course, none of this is possible without the people behind the system. And what folks don't know is that thousands of Canadians actually help shape the standards landscape. So there's more than 15,000 Canadian experts who are contributing to our national standardization system annually. So this participation, these are volunteers, is worth over 100 million in-kind contribution, and it reflects the depth of Canadian leadership and engagement across industries. These experts from all over Canada shape the safety, sustainability, and interoperability frameworks that enable innovation. Like Craig said, if you look around you, everything that you touch and see and put in your hands probably has a standards component to it. So standards that are being developed for clean fuels or data privacy or wildfire resistant construction, our contributions are helping Canada lead globally and to keep us safe at home. So to make all this work, we rely on our accredited partners. So I want to talk about how we empower our organizations to develop standards on Canada's behalf. SCC has accredited 15 standards development organizations, which is up from 4 in 2012. So the growth highlights that Canada's increasing need for responsive, credible, and specialized standards development. So these SDOs, they cover everything from hydrogen fuel infrastructure to responsible AI, and their standards are helping Canadian technologies meet global expectations and open new markets. The other arm of our organization is our accreditation branch. And accreditation doesn't stop at standards development. It also extends to every part of the system that ensures trust and quality. And here's how we lead on that front. Accreditation ensures competence and builds trust. So for example, if a testing lab is accredited to assess medical devices, regulators and international partners know they can trust its results. So if we're developing a medical device in Canada, it's tested in Canada, but it's being sold internationally. We have mutual recognition agreements that those results are accepted and it doesn't have to be retested. In 2024, we had 629 clients. So that's 11 accreditation programs and a 94% satisfaction rate. So if you think we have 629 clients, imagine how many clients those clients have. So from cybersecurity to energy efficiency, accreditation supports credibility and competitiveness in so many different sectors. So speaking of those sectors and Canadian priorities, our work goes beyond the technical oversight. So we're deeply aligned with Canada's broader priorities, especially since we're a government department. We're very much focused on economic growth to climate action. So let me show you what that looks like in practice. We align the work that we do at the Standards Council of Canada with national priorities. So for example, growing the economy through market access, advancing digital trust and AI governance, supporting climate actions, ensuring safety, and promoting inclusive participation. A good example of this is the work that we do with Indigenous communities to co-develop climate adaptation standards that are tailored to local realities, ensuring that resilience is equitable. One of the most practical ways that businesses interact with standards right now is through regulation. Businesses tend not to use a standard unless they have to do it. Some of them don't realize that benefits if they voluntarily do it. The impact of standards on regulatory frameworks is also growing. So standards aren't just best practices, they're often embedded in law. So there are standards that are voluntary, but also standards that are mandatory. And we found, we've done searches on our side, we have over 5,000 standards that are referenced in provincial and territorial regulations, and this was in 2023 alone. So that's just to give you a snapshot there of what that looks like. This means that companies engaging with standards early can get ahead of regulatory requirements, reduce risk, and scale faster, especially in sectors like medtech, clean tech, and aerospace. If a standard is referenced in a regulation in BC, and it's also referenced in a regulation in Ontario, then this helps give broader market access across the country. Of course, Canada doesn't operate in isolation, so we can look at internal trade, but we also have to look at external trade. Let's explore how we ensure Canadian voices are heard on the international stage where many of these standards are shaped. So SCC represents Canada at ISO and IEC, which hopefully you're all familiar with, and other global bodies. And our presence there helps to ensure that Canadian economic interests are advanced, that Canadian values are promoted, such as equity and sustainability, and that we're moving technical barriers to trade through standardization. We also support small and medium enterprises and researchers in joining international technical committees, giving them a seat at the table where global rules are written. So now that we've set the stage, let's dive into today's main focus, which is how does intellectual property and standardization intersect? And Craig did an amazing job at highlighting many of the benefits. We also want to talk about why this matters more than ever for Canadian innovators. So here's the core idea. Standards define how technologies work together. IP protects how your innovation is built. And when you integrate your patented technology into a standard, you elevate its visibility, its legitimacy, and commercial value. The risk, if you're not at the table for standards development, someone else's technology might set the standard, as Craig talked about with Etsy. The reward, if your IP becomes a part of a widely adopted standard, your tech becomes essential worldwide. So how do we leverage standards, patents through standards? And how do they come together in practice? So I want to explore two core strategies that innovators can use. One is influence a standard to align with your IP. And then the other one is to embed your patent in the standard, creating a standard essential patent. Either way, you shape the market. So for example, a Canadian battery innovator could ensure that emerging EV charging stations included protocols that optimized for their patent storage technology. To understand when and how to act, it helps to look at the standardization process itself. And this next slide shows where IP owners can make strategic moves, the one that we're on now. The process map shows the flow from idea to standard. So IP owners can intervene by proposing new work at the international standards table, leading technical committees, or submitting use cases or testing data. And early engagement ensures that the technology is included in a standard's DNA. Now let's look at a real example of a Canadian company that used this strategy to their advantage. Some of you may be familiar with AML Oceanographic, which is a BC-based firm. They developed advanced marine sensor technology. And they didn't just protect it with patents, they led the development of the ISO standard that embedded their technology, technical approach. And that move gave them credibility, early market access, and helped define the performance baseline in their fields. Another good example, and this time it's on a global scale, is Adobe, which you're all familiar with. And here's how they turned their IP into a widely adopted standard. Adobe's PDF format became a global standard after they offered royalty-free access to their essential patents. And that strategy turned a proprietary product into an industry default. And it also opened up new business models from document readers to cloud-based editors. So as you can see, these examples show that there's more than one way to win. The key is having a strategy that combines your innovation and the standardization ecosystem. So this can be whether you influence the rules or make your tech essential. The strategy is to integrate the intellectual property with standardization so that it can enhance a return on investment, boost legitimacy, guide future tech trends, or create licensing opportunities. Think of it as moving from defending your IP to leveraging it at scale. So how do standards and IP relate? So if you take a step back and see how these systems relate at a conceptual level, this visual helps illustrate the overlap. This chart's where IP and standards overlap. Standards increase adoption and IP protects innovation. Together, they create a framework where your technology is both protected and required, which is a rare but powerful combination. Of course, IP and standards don't always align perfectly, and I want to talk about where a friction might arise and how to manage it. Yes, there's tension. Patents equal exclusivity, and standards equal openness, but it's manageable. So for example, by licensing your IP in FRAND, the fair, reasonable, and non-discriminatory terms, you protect your value while enabling adoption. So with some tension, when used together, patents and standards can amplify each other's strengths. So here's how. Using both strategically lets you secure global access, influence the direction of your sector, monetize your innovation without losing control. So let's take an example of a Canadian water tech company. It could make its filtration technology the basis of a global sanitation standard. So that means scale and recognition while still owning the core IP. But embedding IP into a standard isn't without its challenges. So for example, transparency. You must disclose your IP during the standards development process, which some companies may view as risky. FRAND commitments. Most standards development organizations require that essential patents be licensed on fair, reasonable, and non-discriminatory terms, and that limits your ability to control pricing or exclusivity, as you heard in Craig's presentation. Timing and influence. It takes early and consistent engagement to shape the standard, and if you miss key stages, your technology may be excluded. It takes over 2 years to develop a standard. Legal and policy complexity. You may have to navigate international intellectual property right policies, which can vary and sometimes conflict. So despite these hurdles, the benefits often outweigh the risks, especially when you approach the process strategically. SCC and our partners help innovators understand these trade-offs, engage early, and use both tools, IP and standards, effectively. So what's next? As we look ahead, Canada has a real opportunity to lead by embedding our technologies into the systems that define global markets. As innovation accelerates, Canada must not only create new technologies, but we also have to embed them in the global frameworks that are defining compliance and trust. And so SCC hopes to help innovators in this process. So help engage early in standardization, help understand different IP strategies, and help build influence through participation. And with that, I want to sincerely thank you for your attention and interest today. And here's how you can connect with SCC if you would like further information. I want to thank you for allowing me to join. I hope the session highlighted how standards and IP can be mutual tools for growth and leadership. But if you'd like to explore how to align your innovation standards, embed your patents, or just better understand how to engage, then please reach out to me or to anyone at SCC. Thanks so much, and I will pass it back to you, Craig.
Thank you, Annika. That was a very interesting presentation, actually, and it definitely showed us how IP and standards can work to drive Canadian leadership. I especially like the example of I think it was AML oceanographic. So yeah, very interesting. Just a technical note: we have had a few we had a few attendees message in that they were having problems viewing the slides. They were wondering about the availability of slides after the fact. CIPO will be hosting this video on our website, and there will be that French video as well. So if you are joining us from a phone, or if your computer settings are set up in a way where you're not seeing the video and you're just getting the audio, Please just stay tuned. Watch the CIPO website for when we load that video, and you should be able to sort of connect the slide content with the verbal notes. So that said, let's keep the momentum going. Our next presentation brings us into the international dimension of dispute resolution in standard essential patents. Please welcome Heike Volgast, head of the IP disputes section at the WIPO Arbitration and Mediation Center, and Justine Ferland, legal officer at WIPO. And they're going to speak to us about the tools WIPO offers for resolving SCP disputes through mediation, arbitration, and expert procedures. So I'll turn it over to both of you. Thank you.
Thank you so much, Craig. Good afternoon, and very warm welcome also on behalf of the WIPO Arbitration Mediation Center to everyone to this webinar. So we will move with this next presentation a little bit to the dispute side of standard essential patents and to ways to resolve them out of court through mediation and arbitration. And from the experience of the WIPO Arbitration Mediation Center, as you will see in a moment in more detail, this really is an area where we see a lot of interest in recent years by companies involved in the standardization process, but also a bit more at the policy level. And we have a quickly growing mediation caseload in this area. I will hand over in a minute to my colleague Justine Ferland to take you through that presentation. But before I do that, I also wanted to thank once again CIPO, especially Craig and the whole team for the collaboration that we're having also in organizing this webinar. So Justine, I'll hand over to you to take participants through the presentation, and I look forward to any comments or questions that you may have after that. Thank you.
Thank you, Heike. We're very happy to be here today. I will be starting with just a quick word about the WIPO Arbitration and Mediation Center for those who may not be familiar with us. So the center was established in 1994, so we have over 30 years of experience in dispute resolution. And our role is to facilitate the resolution of commercial disputes between private parties that involve IP or technology issues using alternative dispute resolution procedures, so procedures other than court litigation. Our main office is in Geneva. We also have an office in Singapore and a presence in China through what we call the WIPO Shanghai service, but we do administer cases all over the world, including some from Canada. Because WIPO is a specialized agency of the United Nations, we are internationally neutral. We're not linked to a specific jurisdiction, and this neutrality is often seen as a key advantage for parties to an international dispute, because then no one has a home court advantage over the other. And as Craig mentioned earlier, disputes relating to SCPs are often international. We also have users from all around the world, as I was mentioning. And one thing that distinguishes the WIPO Center is that while we can administer any type of commercial dispute, like any other ADR service provider, we are specialized in IP and technology, which means that our procedures are designed with the specificities of these disputes in mind. And this has some advantages for SCP disputes, as we will see in a moment. Also, to assist parties in resolving their disputes, we maintain a list of more than 2,500 mediators, arbitrators, and experts worldwide, including from Canada. And given the technical nature of some types of IP disputes, we also have some sub-lists of experts that have industry-specific expertise, including in the area of SCPs. Our services include mediation, arbitration, expedited arbitration, expert determination, and domain name dispute resolution. And before we go any further, I think it's important to distinguish between the different types of ADR procedures for those who are not familiar with them, because these procedures are quite different from one another. So you have first mediation, which is an informal consensual process in which a neutral intermediary The mediator will assist the parties in reaching a settlement of their dispute, a settlement that is based on the parties' respective interests. The mediator cannot impose a decision. It's not a judge or an arbitrator. His role is to help the parties negotiate, to overcome any deadlocks that they encounter, and find a solution to their dispute, which will often end up being more of a business solution than a purely legal solution. The settlement agreement has the force of a contract, so if one party does not respect its terms, the other can ask national courts to enforce it. And mediation leaves open available court or arbitration options, so it's often used as a first step in the dispute resolution process. Then you have arbitration, which is also a consensual procedure, but it looks a lot more like a judicial process with some differences. It's a procedure in which the parties will submit their dispute to one or more chosen arbitrators who will issue a binding and final decision that is called an award, and that is based on the parties' rights and obligations under a specific national law that they have chosen. This award is enforceable internationally if one party does not respect it, and arbitration normally forecloses court options, so it's either one or the other. And at the WIPO Center, we also offer expedited arbitration, which is a form of arbitration that is conducted in a quicker time frame. Some steps are condensed and involves lower costs for the parties. And then we have expert determination. It's something that we see a bit less often, but that can be useful in the context of SCP disputes. It's also a consensual procedure in which the parties will submit a specific matter, which is often a technical question, which could be, for example, the determination of a FRAND licensing rate, to one or more experts who will make a determination on the matter. This determination can be binding or not. Under the WIPO rules, it's binding unless the parties have agreed otherwise. An expert determination can be used either as a standalone procedure if only one or two technical questions are in dispute, or in the context of a broader mediation or arbitration procedure. Now going back to the WIPO Center, this slide just shows that the number of cases that are being referred to the WIPO Center continues to grow each year. Last year, we administered more than 850 cases. This includes all types of procedures, but I would say that they are mostly mediation cases. We really see a growing interest in mediation, and that's also true for SCP disputes, as we will see in a moment. A few words about the WIPO ADR rules that were last updated in 2021. They are applicable to all types of commercial disputes, but specifically designed for IP and technology disputes. And notably, when you look at confidentiality, the WIPO rules provide a strong confidentiality framework, which is often critical in the context of SCP licensing, where SCP holders and implementers often are direct competitors or they operate in highly competitive markets. They also have to share very confidential information, such as comparable licenses, technical specifications when they negotiate FRAND licensing terms. So confidentiality is often seen as a very important element. The WIPO ADR rules also allow a high degree of party autonomy. The parties can really tailor the procedure to suit the nature of their disputes, choice of law, language, seat of arbitration, all the procedural steps. So the WIPO rules are flexible. So they are here to structure the procedure. They give a general framework to work under, but they can be modified or set aside by agreement by the parties and the mediator or arbitrator. The WIPO rules further provide for online filing by default, and they also encourage remote hearings and meetings, allowing the full procedure to take place virtually if the parties wish, or just part of it. And we can say that in our experience, this works very well, this online conduct, and the results are similar whether the parties decide to meet in person or online. And then the latest version of the WIPO mediation rules also takes into account the Singapore Mediation Convention, which is a rather recent international convention that facilitates the international enforcement of settlement agreements resulting from a mediation. Now, if we look at the benefits of ADR for SCP or FRAND disputes, why should anyone consider ADR instead of court litigation for these disputes? First, because SCP licensing often involves collaborative relationships. For example, if you think about the cross-licensing relationships, and ADR mechanisms, especially mediation, foster amicable settlements and thus help preserve business relationships and long-term partnerships. If we look at the statistics, we see that year after year, approximately 70% of WIPO mediation cases settle. So it's usually recommended to try it. And even if the case does not fully settle, mediation will usually help parties at least narrow down the issues in dispute, meaning that the subsequent court or arbitration procedure is quicker and less expensive. In terms of jurisdiction, it was mentioned, ADR allows parties to an international dispute to consolidate all of their national disputes into just one single neutral procedure and to agree on a global settlement of these disputes, which is of course critical if you want to avoid parallel litigation, the anti-suit injunctions, other jurisdictional issues, especially when you look at the question of determining global friend rates. So instead, for example, of having a first court in country X that will apply one national law or national principles to determine that the front rate is going to be X, and then you have a second court in country Y doing the same thing, and the result is Y, you have just one global front rate that will apply to all national patents, no matter where they are registered. The scope of the dispute can also be narrowed down to only includes the element that the parties deem essential. For example, the portfolio scope, essentiality, geographical scope, or front rate. So it's not necessary to address every single detail in ADR procedure. Then mediation and arbitration enable parties to select qualified neutrals because they can appoint experts that already have technical and SCP licensing experience, which will make the whole process usually more efficient than court proceedings where judges are not necessarily specialized on these very technical topics. They can also choose to appoint bilingual mediators or arbitrators if required. And of course, all of these advantages lead to better efficiency and thus help parties control the time and the cost of the procedure. Then we see that mediation is also increasingly supported by national courts. We are seeing in our caseload an increase in court referrals, and in recent years we have also established a number of collaborations with courts, including courts in China and France. And these courts will encourage parties to a pending dispute to consider WIPO mediation whenever it's appropriate, and they may suspend the court procedure if parties agree to try mediation. So even if you have a pending case, it's not too late to try mediation, and the courts will generally support the parties in doing so. And as I mentioned earlier, you can always go back to the court case later if mediation doesn't work. Then another major benefit of ADR for SCP disputes is that ADR is confidential. As I said, it's often a key point in SCP disputes. And because the WIPO rules were drafted with IP disputes in mind, they really offer a high level of protection. For example, the WIPO arbitration rules will allow protective measures to be put in place, such as an attorney's eyes only declaration or the nomination of confidentiality advisors. And these confidentiality safeguards are often stronger than what's available in litigation, especially in jurisdictions that have quite wide discovery regimes like Canada. And also considering that in Canada, everything that is filed in a court docket is normally public and accessible by anyone, and that it's normally quite difficult to obtain a confidentiality order in a commercial case, parties may prefer to use ADR when it comes to settling their SCP disputes. And finally, because once again, SCP disputes are often international, the international enforceability of arbitral awards under the New York Convention and increasingly of mediated settlement agreements under the Singapore Convention is also seen as a key advantage. And in comparison, enforcing a national court judgment abroad can be difficult, time-consuming, and often costly. Now, if we look in more detail at the WIPO Center's experience in the area of SCP disputes, so far we have administered over 85 SCP or friend-related mediations in the past few years. We've seen all types of parties, SCP holders, implementers, patent pools. They were from more than 20 jurisdictions across North America, Asia, and Europe. They included global players, SMEs. We really see the whole spectrum of players in our cases. Many of these cases were filed in the context of pending court litigation in multiple countries, which once again shows the appeal of ADR in such situations. And as I mentioned, we also have a dedicated list of SCP mediators, arbitrators, and experts that can be appointed in such disputes. They are based, once again, all across North America, Europe, and Asia. So we really try to accommodate the parties' jurisdictional language and expertise needs effectively. This being said, the WIPO list is not exclusive, and parties are free to appoint people from outside this list if they prefer. We also make available some free resources online, including some tailored model submission agreements and a guidance document on WIPO ADR options for FRAND dispute management and resolution. And finally, we're also working with some IP offices, including, of course, CIPO, but also the USPTO and the UK IPO, to raise awareness of the benefits of ADR and of WIPO ADR services in this area. Sorry. Now, if you want to use mediation or arbitration, how can you get to it when you have a dispute? So I mentioned that ADR is consensual, so you cannot have an ADR procedure without consent. And this consent can be formalized either in a contract before any dispute arises or once a dispute has already arisen. If the parties have a contractual relationship and they agree that any potential future dispute should be submitted to ADR instead of courts, then they may include a specific clause in their contract to state that. If parties do not have a prior written agreement, for example, because they have a contract, but there's no ADR clause in it, or because they are involved in a non-contractual dispute, such as an infringement dispute, they can still agree, once the dispute has arisen, to go through ADR by drafting what we call a submission agreement, which is an agreement to mediate or arbitrate concerning a particular dispute. This clause or submission agreement can provide for either mediation, arbitration, or expert determination alone, or a combination of two options. This is what we call escalation clauses, where parties will agree to first try mediation to settle their dispute, and if they have not settled in a specific period, let's say 60 or 90 days, they will move to arbitration or court litigation. Since most FRAND disputes are non-contractual, we also make available some model submission agreements that are specifically tailored to this context. You have the link on the slide. Then, of course, as I mentioned, we also receive an increasing number of SCP mediation cases that are court referrals. So that's another way to get to ADR. If you have a pending court case, you can put a hold on the court case and go to mediation. And then parties can also choose to use mediation not in the context of a current dispute, but to assist them in their contractual negotiations. In other words, to facilitate the conclusion of a contract when the negotiations are proving to be a bit difficult, even if there's no dispute per se. And this is what we call deal mediation. It's something that we see quite regularly in the context of SCP licensing, because negotiating a license on FRAND terms can often be complex. It's sometimes contentious, especially when parties disagree on the definition of what are FRAND terms in their case. So in these situations, parties can choose to appoint a mediator to facilitate constructive dialogue between them. The mediator will help them clarify their expectations, express their needs, and will support the drafting of balanced and durable license terms. And we've seen a couple of these deal mediation cases between SCP holders and implementers, often in the context of licensing of large telecom patent portfolios that concluded with the parties entering into new commercial agreements. And then finally, another possibility, which in our experience can be very useful in some cases, is the option to start the mediation process with the filing of a unilateral request for WIPO mediation under Article 4 of the WIPO mediation rules. Now, of course, I said it, mediation is consensual, so it's not a way to force another party to participate in mediation, but it's a way for one party to invite the other one to consider mediation whenever there's no prior agreement to that effect. And I'm showing you here what this unilateral request looks like. As you can see, it's quite simple. The requesting party only needs to indicate some contact information of both parties, a brief description of the dispute, and then we'll submit either through email or through the WIPO IP portal. Then once we receive the unilateral request, for mediation, we will get in touch with the other party. We will inform them of this request, and we will share some details on WIPO mediation. We can also have a call with them if they're interested, and we can do that in multiple languages, including, of course, English and French. So if they have questions, sometimes it's easier to exchange over the phone, but the goal is to help them take a decision as to whether they wish to participate or not. Then if the other party agrees to participate, the mediation will start. If it does not, of course, there's no mediation, but the filing of the unilateral request is free of charge, so the requesting party does not have much to lose by trying it. And actually, we see that it does work in some cases to have a neutral institution like the WIPO Center communicate the request to the other party and share further information about the mediation request. And in some cases, the other party will accept to participate in mediation after we contact them, whereas they would not have necessarily accepted if the request had come directly from the party with whom they have a dispute. And in other cases as well, the mediation does not take place, but just filing the request helps facilitate a return to private negotiations outside of the mediation context. It's also sometimes a way for the requesting party to record its willingness to refer the dispute to mediation and to attempt to settle it out of court, which can have some strategic value in some cases. And then I'll conclude by just sharing a few recent success stories in the SEP dispute area. This first case example involved an international player in the wireless communication technology sector and a smaller company on the implementer side. So on the one hand, you had an Asian telecommunication company as the patent holder. And on the other side, you had the European consumer electronics manufacturer as the implementer. They were involved in court proceedings that were pending in various jurisdictions, and the dispute centered around the negotiation of licensing terms for SEPs that were related to wireless communication technologies. A key issue in this case was whether the proposed royalty rates complied with FRAND obligations. And then at some point during the pending court disputes, the parties jointly agreed to refer the matter to WIPO mediation through a detailed submission agreement. And this submission agreement outlined the scope of the mediation and reflected also both parties' willingness to engage in this neutral process. So a mediator was appointed by the WIPO Center. It was someone with deep experience in IP law and the telecom sector. And in summary, the process included first written mediation statements that were submitted by each party. Then they had a virtual preparatory meeting with the mediator. Then they had separate caucuses or private sessions between each party and the mediator. And then when a mediator felt that everybody was ready to meet, they had a one-day in-person mediation session followed by a brief joint virtual follow-up session. And this mediation allowed the parties to successfully reach a settlement within 6 months of initiating the mediation. In the context of the settlement, a final license agreement was concluded, and the pending litigation in all the jurisdictions was withdrawn. Then we have another example of a European telecommunications company and an Asian electronics and communications company that were also involved in parallel litigation in multiple jurisdictions. In this case, they were both quite big global players. The dispute concerned the determination of FRAND terms for a global cross-license agreement that involved both parties' portfolios of cellular SEPs. And the main issues were the determination of appropriate friend royalty rates and the scope of the license as well, including territorial reach and product coverage. So once again, the parties jointly agreed to refer the matter to WIPO mediation. They concluded a submission agreement because they were already in dispute. And in this case, we appointed a bilingual mediator who spoke both English and Chinese with relevant SEP expertise to guide the whole process. And in this case, the parties were very concerned with confidentiality of the information exchanged. So the mediator established a detailed confidentiality protocol to manage submissions and to protect sensitive data, including regarding the comparable licenses. The parties also explored the appointment of the idea of appointing an independent expert to assess these comparable licenses, but ultimately they did not pursue this. Then they had some virtual mediation sessions, also separate meetings that were held between each party and the mediator. And through this whole process, the parties engaged in structured negotiations with the mediator's facilitation. And once again, the result was a full settlement under which the parties agreed to a global patent cross-license agreement. One last example of a unilateral mediation of a friend dispute that involved a patent pool this time. So we had a European patent pool administrator and an Asian electronics manufacturer that were engaged in negotiations regarding friend licensing terms for a digital broadcasting patent pool. And despite earlier license offers and follow-up exchanges, the parties were unable to reach an agreement. They were negotiating in good faith, but it just didn't work. So at some point, one party submitted a unilateral request for WIPO mediation because they had, once again, no pre-existing agreement to mediate. And we facilitated the process by providing communication channels and procedural guidance to both parties. And in this case, what happened after that, our initial contact with the parties, was that the parties were able to re-establish a constructive dialogue. And in the end, they decided to continue attempting some direct negotiations first before moving on to mediation if necessary. And in the end, a settlement was reached before they moved to mediation. So no mediator had been formally appointed. And just through continuing these private negotiations, both parties agreed to and signed a licensing agreement. So in this case, the total cost of the procedure was zero. No mediator was appointed. Yet simply by filing the unilateral request, there was a positive outcome to this case. So I'm stopping here, but for more details, please feel free to reach out to us by email or visit our website. You'll find our rules, model clauses, guidance documents, as well as links to newsletters and other webinars on this topic. So thank you very much, and we're happy now to take any questions.
Thank you very much, Justine and Heike. And of course, thank you for being here today and helping to organize this webinar. That was a fantastic idea that you presented us with. That was an excellent presentation, very insightful overview into how the WIPO Arbitration and Mediation Center can support parties that are navigating these complex processes. And maybe importantly, as you mentioned, in a neutral manner that's really central to the UN mandate. Okay, so this concludes the presentations that we had for today. Today we learned some of the basics behind standard essential patents. We learned how IP and standards intersect, and then we learned how disputes in this space can be resolved through alternative dispute resolution. For those that are interested, we're going to open the floor to a Q&A session. For this part of the webinar, we're also joined by Mr. Mark Corus. He's the Senior Policy Advisor at the Strategic Policy Sector at Innovation Science and Economic Development Canada. Mark has extensive experience studying these issues related to standard essential patents. And so this is your chance to dive a bit deeper on this topic. So feel free to put questions in the chat. I know we have received some questions privately to our administrator, and I thank the team here at CIPO who's managing that. But if you want to maybe get a more direct line to the panelists, just ensure that when you do enter a question that you assign it to everyone. But we do have a few in the queue. So maybe I'll pass the first question on to Annika at the Standards Council of Canada. You mentioned in your presentation that it could take up to 2 years for a standard to be developed, and you were encouraging companies to consider being part of that process. That sounds like quite a difficult process to navigate. It sounds hard. Maybe can you unpack that a bit and maybe talk about how companies can get involved and what's involved?
Sure. Well, to be involved in any type of standards development, especially if it's international, then you have to go through the Standards Council of Canada. So we're always looking for experts. There's hundreds of technical committees on all sorts of topics. And so the first step, if you are interested, is to contact the Standards Council of Canada with the area of interest that you have, and we can walk you through, what technical committees are active and what they're working on. This is also available through the ISO and the IEC website and our websites as well. You have to become a member to a MIR committee. So every country has MIR committees to the international technical committees. And that's where Canadians come with their positions that they bring to the international standards development table. And so you're with other experts, and if you want to become more involved and you actually want to participate internationally, become a convener or project editor, then there's pathways to that as well. Participating in national standards development, you would also contact the standards development organization directly, but we're also happy to help direct you there if you need help navigating it.
Okay, that's excellent. Thank you, Annika. So SCC is a good resource for innovators that are looking to get involved in this space. We have another question related to time and money savings with alternative dispute resolution. So how long does an SCP mediation usually take? What does it cost? Can you maybe comment on the type of savings that parties might see? And obviously this is for Heike and Justine. Thank you.
Sure. Thank you. Shall I start, Justine? And you feel free to add. So thank you, Craig, for the question. So concerning the time, so the process of the mediation is entirely in the hands of the parties and the mediator, and we have seen, especially in the SCP France space, very different arrangements. I think it really will be in line with the complexity of the dispute. So the typical mediation normally is conducted within 3 months, and most of the time, goes into the agreement between the parties and the mediator to find the time to have the mediation session and the preparatory meetings. It can also happen much quicker, especially in court-related mediation. Sometimes the judges give the parties only a couple of weeks, then that's fine, and the process can be adapted. Some of the very complex SCP mediations that we have seen, as Justine was mentioning, with very large companies involved in litigation in a number of jurisdictions, the process can be longer, and sometimes they wait for the outcome of one litigation in one country that will then determine the negotiation. So, but I think the response is really very flexible and will be adapted to the specific case. But typically, it can be conducted quite quickly, and in a way that has also an impact on the costs. Of course, there is a small administration fee, and we have a schedule of fees. There you have the link to that in the slides that Justine just showed. We offer a couple of discounts, especially if SMEs are involved, and we see that is often the case in the SCP space. We really want to make sure that the procedures are accessible. And then the costs relating to the mediator again will depend a little bit on the amount of work that is required and the complexity of the dispute. But I think that's outlined in the schedule of fees.
Thank you, Heike. I hope that answers the attendees' question quite well. Maybe we'll stick with WIPO now that we have you here. Our next question is related to the willingness of the parties, I suppose. So I imagine success rates are probably better when you have willing participants on both sides. What happens when a party files a unilateral request for mediation? Do you see that often, and what's involved there, and what's the success rate look like?
Do you want to start, Justine? You just spoke about that in your presentation. Perhaps you can.
Yeah, as you wish, I can start. So,
Go ahead.
yeah, of course, not all unilateral requests will lead to a mediation. It happens that in some cases, the other party will either not reply at all or reply that they're not interested. And if they do so, of course, it's fine, and we close the case, and parties can explore other options that they have. This being said, we've also seen, particularly in the context of SCP disputes, a number of unilateral requests having a positive effect, as I mentioned, either leading to a mediation, a full-on mediation, or simply helping revive private discussions between the parties. So if you put these two elements together, I would say that the success rate with regards to SCP disputes specifically is quite good. I don't have a specific number, Heike. I don't know if you have a number in mind, but it's generally something that is has quite a positive impact on the process in this specific area. In other areas of IP, it's a bit more difficult, but in this one specifically, it works quite well.
Thank you. And perhaps just to add to what Justine said, what we hear from parties, that have been involved in these unilateral requests is that often, they have in the negotiation, perhaps one party has already raised the possibility of a mediation, but then the other party didn't really agree or didn't really understand what the impact would be. So I think this sort of formalization through the unilateral request, and then for us as an institution to be available, to just reply to these questions and explain the process, that really has made a difference and has been quite successful, especially in the SCP space, as Justine was saying. Yeah.
It's excellent. Thank you, Heike. Maybe just a reminder, if you have any questions, to select the Everyone tab. I think maybe some of them are defaulted to our admin, but and that way everyone can also see the questions that are being presented. We did have a question. Maybe I'll pass this along to Mark, but it had to do with locating standard essential patents, and how do you find for particular industries the list of patents that are declared standard essential? Maybe you could unpack that a little bit. Thank you.
Yeah, sure, I can take that. A good place to start is usually the standard development organization or the standard setting organization that's responsible for the standard that you're looking to implement. As was mentioned in the presentation, it is often the case that these organizations require their members to declare when they have patents that read on the standard, and they will usually make these lists public so that you can get a list of all the declared patents under that standard. There's also industry-specific collectives or patent pools that you can talk to depending on the technology. So, for example, a good well-known pool would be Avanci, which licenses telecom patents for vehicles. And so those are other areas that you could go to. Sometimes they're even available on different terms, royalty-free, negotiation-based, and other. And finally, I should note that just like any other product, it is usually a good idea to check with a lawyer or patent agent to do a freedom to operate search, just in case there are any patents that read on your product before you launch.
Thanks, Mark. Okay, we still have quite a bit of time left here, 20 minutes. We have a couple more questions that are in the hopper. Maybe I'll go back to the WIPO Arbitration and Mediation Center. You mentioned that confidentiality was an advantage of alternative dispute resolution, and that the WIPO rules include strong confidentiality provisions. Can you maybe talk about that? What does that look like in practice for parties that are engaging in this process?
You want to go ahead, Heike?
As I wish.
Yep.
Okay, I'll start, and then you can thank you, Craig, for that question. So as Justine was mentioned, the WIPO rules were drafted, and updated with IP, including patent disputes in mind. So they have a number of tools already available. to make sure, to offer this level of comfort to parties concerning the sharing of confidential information. Now, in practice, especially in SEP cases, we see in many cases that's sufficient and fine, and the mediation is conducted just under the WIPO rules. But in some cases, parties are very concerned, and want to add additional layers of protection, and of course the main topic are access or non-access to comparable licenses, which obviously companies are very careful not to share, or not to share fully, or only to share with the mediator, or only to share with counsel of the opposing party. So we see all types of solutions that are being discussed. And then what happens typically in practice is at the very beginning, well, sometimes parties, even when they submit the case to us, to the WIPO Center, in the submission agreement, they can, set up all these details if they agree. This is, of course, one option, and we see this in some cases. In some other cases, they are not really able to agree, or they don't anticipate this at that stage. And then what happens once we have appointed the mediator or the arbitral tribunal, then there is this first case management meeting with the parties, and then the topic will be brought up, and then the mediator will work with the parties to establish what we call a confidentiality club or a confidentiality protocol. Of course, we can help again as an institution. Of course, we have seen many of these arrangements, so we can share some information. But this is a very careful exercise, and it's agreed in the end between the parties and the tribunal or the mediator to make sure that there is this safe framework under which parties are comfortable sharing information. At the same time, to be able to share sufficient information to make the mediation successful, and to be able to assess, what would be front in terms of royalty rates.
Excellent.
I hope that answers the question.
Thank you. Yeah, that was very clear. Yeah, thank you. We have a question. Maybe I'll direct it to Mark. Given the patchwork of national initiatives emerging in this area, what prospects do you see for coordinated international frameworks to reduce fragmentation, I guess, and maybe to avoid duplicative compliance burdens? Maybe I'll add to that. Maybe you could also just speak to some of the Canadian efforts in the policy space and the area of standard essential patents, just to give the audience a sense of where we're operating.
Sure, I'd be happy to. So yes, I do take the point that there are varying regimes internationally, as you all know, or maybe not. Patents are granted on a national basis, and they are usually enforced on a national basis, or sometimes a regional basis, such as in Europe. And that can lead to differing regimes around the world. And when you have standards that are implemented on a global basis, such as with telecom, for example, that can cause issues. We're also starting to see a higher prevalence of things like anti-suit injunctions, where courts attempt to seize jurisdiction over an issue and discourage going to another court to try and get a parallel judgment on that issue. This can present problems for the parties because you don't want to end up in a situation where you have conflicting court decisions and conflicting jurisdictions, both of which say you need to do different things. Speaking from our perspective, Canada has been fairly interested in having an international discussion on this point, because we do see that there is starting to be more conflicts generated in this space. And so some type of open discussion between nations about how this is working, what are the problems, and if there are any potential solutions could be valuable. We've done some very minor things just to kind of dip our toes in the water in terms of SEPs. For example, we have a piece of legislation in Canada that requires that licensing commitments follow the patent. So if a owner of a standard essential patent makes a FRAND commitment and then sells that patent to another party, that party would also be bound by that FRAN commitment. Now, granted, this is national legislation, and like all legislation, it only applies in our jurisdiction. But that's why we feel the need to have these discussions. We do regularly speak with various nations on this point, for example, at WIPO through the Standing Committee on the Law of Patents, where this topic has come up, and we have presented some things in the past on this subject. And we're definitely interested in continuing those discussions.
Okay, that's great, Mark. Thank you. Very informative. We have one more question, and if there are none that sort of populate the chat before the answer to this one, maybe we'll sort of move to close the session. This one is maybe for the Standards Council of Canada, and I have misplaced the question, but here it is. Okay, with AI, quantum, and clean tech standards evolving rapidly, how is the Standards Council of Canada ensuring that Canadian technical experts have both the resources and the mandate to influence those discussions rather than just react to them?
It's a great question. And we're very focused at SCC at supporting small to medium enterprises in Canada, since they also make up 99% of our economy. The best way to influence is to become part of a mirror committee. But we do understand too that takes time away from if you're a small business that has a handful of people, that might not be a possibility for you. So we're always looking for creative ways to reach the different Canadian communities who want to have a voice. One thing that we have done is we have launched what we're calling our AI and Data Governance Standardization Hub, where we're trying to provide a one-stop shop for, in particular, small to medium enterprises to understand how to navigate the standardization ecosystem. So bringing the information to you so you know that what's important, what you have to pay attention to. We also provide a small amount of funds for people to participate in standards development. This is a bit of a touchy subject because it is a very small amount, and we tend to provide that funding to high priority committees, which AI, quantum, clean tech are high priority committees for us. So we tend to provide a little bit more attention, especially from a policy perspective, so that we're helping folks participate where they want to participate, but making it easier for them as well. That is the best way to influence, is to become part of the mirror committee. That's not possible for you, then contact us. Let's figure out creative ways to get you the information that you need. Because we're such a small organization, we can be very hands-on and we can be very personable to help work one-on-one where we might help support Canadian innovators.
Thank you very much, Annika. I don't see any other questions. Maybe I'll do the classic going once, going twice sort of call out. And that's fine if there's no other questions. We took a healthy number of questions, I think, during the Q&A. And the presentations were very clear and informative, so maybe that's a testament to how informative they were. Okay, well, with that, maybe I'll then move to close the session. I want to thank all the speakers for their insights and for being here today to provide your perspective on issues within the SCP and ADR space. Huge thank you to the staff at CIPO here that helped with the registration, promotion, and just to make this session run so smoothly. There's many names, maybe too many to list. Today's discussion really highlighted that not just the importance of IP and standards, but also the tools that are available to innovators and businesses to resolve disputes effectively. So we hope that you leave with new perspectives, maybe new ideas to carry forward. There's obviously a lot of resources that were presented by WIPO and by the Standards Council of Canada. And again, maybe watch the CIPO website for a recording of this video and a recording of the French video. So with that, thank you once again, and we'll conclude the session. Bye, everyone.